account. She's the one who used to call them or arrange with them how to disperse the monies. So, so since we were following this 500,000, which was one of the matters which we had to look into, then we had to subpoena the bank statements.
Good. Okay. So this is now a new source of evidence, as it were. You have the testimonies of the people, you have the emails, and now you have bank statements.
Correct.
Okay. In the spirit of following the money or following the evidence, a la Mail and Guardian, correct?
Mail and Guardian, yes.
Mail and Guardian case. Yeah. All right. So now let's then go to some of the recipients or beneficiaries. I think that's what you call them, of the amount. If you go to 5.3.10.60, page 82 of the report. Oh, sorry, Chair. Okay. Okay, before we get to that list of monies, can we just round this up? We left your statement after you read out those names at page 26, rather paragraph 260.
Okay.
Just go a little bit up, a little bit down or whatever. Yeah. Okay, that's fine. I'm just for members to know that this paragraph follows the one where we had left the statement. Yeah. Okay. And this is just two paragraphs which I want you to go through so that we don't come back to the contents of the emails. This is, if you like, a cross-section of the emails, and which indicated to you that the president knew what was going on. We'll come to that later. But can you place those two paragraphs on the record?
There?
Yes. 260 and 261.
Okay, so the 260, there's the email. There was another email which was the further evidence that showed that on the 12th of November 2017, Ms. Nichols had sent an email to the president stating that Stavros says the following will fund if we had a small cocktail party. I need to discuss diary with you. And then 261, during the investigation, there was a further uncontested email from President Ramaphosa to a person named Donald, which stated the following. Hi, Donald. Thank you for assisting with the internet banking the other day. Could you kindly transfer an amount?
Sorry, can you? That's what?
Okay.
Okay.
Yeah,
take it up until the account number.
Yeah.
Just go up.
Yes. Yeah. When I say until, I mean excluding. Yeah. Thanks, Chair.
Until account number. Yeah.
Yes, right there. Okay.
Yeah. You can push it up a little bit. Yeah.
No, if you push it further than that, the account number will show.
So Could you kindly transfer an amount of 20 million from the money market investment that was left after we shifted 75 million from the money market select to reattender trust Standard Bank account?
Account number, blah,
Account
blah.
number, so and so.
Mm.
And then I shall call you to confirm all this, Cyril.
Yes. Okay. Okay. I'm trying to be creative here, Chair. Okay, can you now move it up, but the account number must still not show. So
Yeah, it
that's,
doesn't show.
yeah. Yes, okay, that's perfect. That's perfect. Well done, Sepo. Yeah. So, okay, apart from the sentence that we have, for obvious reasons, not taken out, the last is Cyril, meaning that's the sender of the email, correct?
That's correct.
Good. All right. Now then we can go to
262.
262. Yes, 262, so that we just get there's no account number, just the entities here, correct?
That's correct.
Mm.
The investigation revealed that several accounts were used to mobilize funds for the CR17 campaign. This included Reattender Trust, Edelstein Faber Krobler, EFG Incorporated, and a company called Linked Environmental Services.
Mm-hmm.
So then 263, some of the beneficiaries of the donations were senior members of the ANC and officials or functionaries of the CR17 campaign, which included Ms. Marion Spark, Mr. Mkhwebane Dukwana, Ms. Busisiwe, and Ms. Kumbutso Nchaveni.
Mm-hmm.
Yes. So 264 millions of rands in excess of 8 million were used to fund only hotel accommodation for several delegates who attended the ANC National Conference in December 2017 in and around Johannesburg.
Okay, just
Yeah.
pause there. Again, it's just my interposing so that people follow the sequence. So we know that we've established that that 500,000 was paid in October 2017, and then the email about the small cocktail party. The people who said they'll fund only if the president comes to a small cocktail party. That is in November.
That's correct.
Okay, that's now a month before the conference.
And I think it should be clear that we were following the 500,000.
Yes,
And
yes.
unfortunately, then when we analyzed the evidence, then we had to uncover something like this.
All this, yeah. Okay, so then it got bigger and bigger.
Mm.
All right, fair enough. And I just wanted to situate the sequence. So it's October, November, and then the paragraph that you've just read now, talking about paying rent for delegates. These are now delegates to the conference. According to that, this is now December 2018. Correct. Okay, that's fine. Makes sense because I know that the conference in December 17. It says 8 million was used to fund accommodation for delegates. We don't know what kind of accommodation it was, but it's either very posh accommodation or many people, whichever it is, yeah. But the figure was 8 million.
That's correct. Remember the bank situation paid where it was also by Mkhwebane interviewing him because saying some money was used for food, for accommodation and all.
Yeah. All right, 265.
Very important economic player, the South African economy paid millions of rands in the campaign, CR17 campaign, raising reasonable that they were and from those and several officials and functionaries of the CR17 campaign, large amount of money. We analyze the bank statement and we could see it move from where to where and how.
All right.
then I
260.
put here and state that records, which include emails and records, which I tend to rely on as evidence, were sealed by the High Court in order to prevent them from being made public. That was done,
Yes.
members, by the deputy.
Deputy Letwaba, that's what I was mentioning earlier.
Yes.
So those bank statements, bank records, and so on, we'll just use them before they were correct,
Yes, so,
analyzed.
yes, after we issue the report, we then saw some information published in the various before sealing it was confirming whoever fitted, whoever donated.
Okay, thanks. We'll do that. Yeah. I think is away from the high court, that's in the all right, 267.
Over and above showing money was moved around, there's records that as the version, the president was ignorant of the identity of the donors of the CR7 campaign. Because this, anyway, when we go to the constitutional court judgment, because we avail of information to the constitutional court.
So now getting closer to what I call observation. And before we do that, just to round off previous issue, go to H, Public Protector 31.7.1 and 31.7.2. I think this should work. Public Protector Office. She also 0.7 this. So that would then be newspaper report. Just move it up. Take out the please. Sorry, Chair.
Pause.
This appears to be a media report. And it's hearsay, so I'm checking the extent at who is now seeking to rely on media reports as opposed to of the script of what was before the public protector and the report and the affidavit. I have some difficulty on the reliance placed on media reports.
Okay, thank you. Madam Both.
No, thank you. No, if you allow this, because it's let me tell you what the purpose is here. The purpose is, as I said, we can't use the evidence that's in that is sealed for obvious reasons. But I want to. I'm not using the newspaper report, let's say, for whatever it was reporting. Let's say the newspaper report was from yesterday, and I've said to you earlier that whatever would have happened yesterday would then not feature in what we're analyzing. But I'm using it for a different purpose, which is to test the evidence that was at the disposal of this witness at the relevant time, not now. The fact that it came out yesterday or whatever is not relevant. That's number one. Number two, I'm not using it to test the the veracity of the newspaper report, which is where the hearsay rule would apply. So it's just to reference the fact that because we're busy here in this inquiry, inquiring into what factors and what evidence was playing in the public protector's mind for her to get into the impugned or the conclusions that are before this committee. So that's really the only purpose. It's a limited purpose. Thank you.
Okay, back to you, Advocate Bauer.
The report comes out in July 2019. This media article is written August 2019. So
Yes.
I have difficulty with, firstly, the hearsay nature of the media report, the slant that's put onto media reports, which we know one can go and dig and find media reports. It's going to tell you, depending on how the author writes it. And thirdly, the public protector can tell us what she had in her mind at the time without resorting to the hearsay evidence of a media report.
Yeah, okay. I hear you, Advocate Bauer. I think I've got them both.
Chair, well, I don't want to preempt you. If you, I'll only talk if you're not going to allow me to ask the question.
You can ask the question.
Okay, thank you, thank you. You heard that, but we do need to be careful. Advocate Bauer is right, yeah. So again, just so that we disclaim any ownership of the media report. We are not here to verify the truthfulness. The journalist can say whatever he or she said in the article. That's not what we want the committee to now adopt, or whatever the journalist was saying. I'm saying the only reason we're bringing this, and number two, Advocate Bauer is also right, that technically, if the report came even a day after the report, then obviously that report did not inform your report. That's just a matter of logic. Did you understand what I'm saying? If the newspaper report came even one day after your the PP's report, then obviously it did not play any part in the report. You accept that?
Yes, it's correct.
Yeah.
Indeed, we don't normally rely on what the media publishes.
Yes. Yeah.
Because as I said, information in the media is information.
Yeah.
We go deeper and investigate.
Yeah.
But if you can hear what I said earlier, that there's somewhere where I mentioned that before the sealing, after we issued the report, there were publications of some of the information,
That's it.
which is I've read here, especially the names and everything, which I can confirm that
Yes.
indeed it was published before the sealing, and indeed it's evidence which was
before
me.
you.
Yes.
That's all. Yeah. No, I'm assisting the chair to say that when he's allowing me to, it's for that limited purpose. Yeah. Okay. Thank you. Or assuring Advocate Bauer rather than assisting the chair. Yeah.
Advocate Bauer, just pause, Advocate both.
Chair, based on that, this
Oh.
Just
Okay. Chair, no, it's nothing of the sort. I don't, it's frustrating. We are trying to get into the truth here, but in doing so, we can't use the committee, as it were, to unseal documents that have been sealed. The witness has made it clear that she had certain information in front of her, and that information was published in these articles, which she is aware of long before the sealing. That's really the only purpose of this. Otherwise I can just ask her to read it out herself, or I can read it and ask her, and then she'll confirm. It's the same thing. It's a facilitation of evidence. It's got nothing to do with the truth of the newspaper report. It's the existence, and Advocate Bauer knows this. There's a difference between invoking a newspaper report for the truth of its contents and the existence, mere existence thereof. There's a big difference. The hearsay rule doesn't apply if you only want to establish that the report was made, not that it's true.
it's important that we stick to what you said at the beginning of what we're not doing here. But I'll give Advocate Bauer before I go to Public Protector.
Chair, one of the reasons for the sealing was the ambit of the Public Protector's investigation, and what the court eventually held was the case and confirmed by the Constitutional Court subsequently as to what was permissible to be investigated under EMEA, and the fact that party political funding didn't fall within that ambit. And a number of the allegations in this media article does go to the expansive funding that went into the CR17 fund, as opposed to what was actually being investigated by the Public Protector. Over and above that, I don't agree with Advocate Mpofu's position, because he is going to rely on the contents of the media article.
Okay, so just your summary of your concretely what your concern and intervention is on.
Chair, my concern is that the media article was not one of the source documents that was before the Public Protector at the time of a report. It doesn't pertain specifically to the subject of the report, and it's not on which the basis of the misconduct and incompetence allegations rests before this committee. So there's nothing in this article that relates to what is before the subject matter of this committee.
Okay, yeah, we'll find we'll have to find a very proper and creative way, Advocate Mpofu, because I do hear what Advocate Mpofu, Advocate Bauer is placing, which is very important.
Yes, no, so do I, Chair.
I'm going to try and lean on you to.
I'll find a creative way of doing it, Chair, that is not going to stray into that issue. But one thing I must make clear is that I am not relying on the veracity of the newspaper report, number one. Number two, we are busy inquiring into what was before the Public Protector. And I am specifically disavowed any, if we remember, the Public Protector had access to these sealed documents, Chair. So we could have just said, oh, well, she's got it and here it is, or put it up in the Public Protector statement, but that would be wrong. So we don't want to do that. All we're doing now is to say, Public Protector, enriching these conclusions for which you are now being impeached, what information was at your disposal? That's really the only purpose. And I thought your ruling made it clear. It's the only limited purpose of leading this evidence. So anybody who's interested in the truth and in what objectively was in fact in front of the Public Protector, I don't know who is being protected now. But no. I think let's protect the process.
Nobody's being protected.
Well,
we're protecting our process.
Yes,
as a committee.
There were
so that you don't put personalities into it.
Okay, good.
It is our process.
Yeah.
Because that's a process that can easily be reviewed if we don't do it properly.
Yes.
You are going to interact.
Can I speak?
Yes. Yes, I think the chair has given you a platform.
Yes, Chairperson and members of the committee. I think I'll ask Advocate Mpofu again to read the charge which I'm facing regarding this matter. And remember, as the committee, you said it, you represent members of the public, and the public as well, they are listening, those who are listening, and they want to know the truth. And this is for me a matter of life and death, because this is about me. I'm the one who's sitting in this stand. I'm being accused of gross negligence. I'm being accused of targeting people. I'm being accused of misconduct. And I think if you go back to the charge, Chairperson, this is what I'm trying to prove, that the evidence which was before me.
This is now
this
11.3 and 11.4. That's the
Correct.
charge.
Correctly.
Patently wrong finding on money laundering, doubting of bona fides of the president without reason. That's the charge.
Correctly.
Yes.
Okay.
That's
That
correct.
sense, yeah.
So, and remember yesterday, I also said, I have been subjected to this persecution, false reporting. Yes, the very same thing you are reading now, because other people, they take it as is. Now, Advocate Bauer comes and say the court found that that was, because that's what the court is saying.
Mm.
And again, those are the facts I don't agree with, because it's in the report. Hence, I said I will deal with the report. I will deal with, at the time, Chairperson, what I was dealing with. Hence, I'm saying the president was the deputy president of the country. The president was subjected to Executive Members Ethics Act. And the president was a member of parliament. And there's a legislation we've mentioned there where we were requesting the speaker to do something, because the president and any of you, even if it's 350, you need to declare to parliament. The investigation at that time was purely based on that. Hence, I'm saying now that on that factual issue, unfortunately, the court got it wrong that I'm investigating the private ANC funding and everything. But even the president himself said to the speaker, that was relating to the ANC campaign and being a leader of the country, which is being the president. So what I was trying to show is that the untouchables, some of them being in the big business, which, yes, the information has been sealed, and hence I'm saying again, the process which was followed in sealing them, which we never agreed with when we were litigating, because it was just sealed in chambers. It was never an issue where both we submit and both it's argued and we see, okay, which information is critical for me to defend myself. So the information which is out there, not to say I relied on the media, that definitely we don't do. What is there in the media after the report is issued, I'm confirming, or I'm trying to prove here that I'm being persecuted, or these untouchables who have donated and who are then also then protected. But my life is in danger here. Well, danger in the sense that indeed it's a matter of life and death, because this is about my future. So the media article, I was going to confirm that indeed the following people were the people who donated or who benefited because of the evidence which was before me. It's not because I'm relying on the media statement, but I'm saying what is published, the information indeed is correct. So it was purely that.
Oh, okay, thank you, Public Protector. I see the hand of Honorable Myla.
Thank you, Chairperson. Chairperson, I just want to correct a factual matter, and that is that the President is not a member of Parliament in terms of Section 87 of the Constitution. That when a member is elected as the President, he ceases to be a member of Parliament at that time. Thank you, Chair.
No, wait. No, thanks for that, Honorable Myla. That would be correct, but if you situate back, then the issue is, which is the argument that at the time. Okay, no, I'm just following, boss. She would have done that before and said at the time, even now she did say at the time he was a deputy president.
Thank you.
And at that time he's a member of parliament. So just to correct that, Honorable Mwala, I see your hand.
No, Chair, I just want to confirm what you've just said. The PP said the president was the deputy president at the time and a member of parliament. So I just wanted to confirm what you said.
All right. Thank you.
Thank you, Chair.
Advocate Bao.
Oh, sorry.
Chair, Advocate Mpofu said he's not going to rely on the contents of the article. The public protector has now said she is relying on the contents of the article. That she
Chair.
does want to refer to the names, etc., in the article,
No.
and who benefited and who donated and who didn't. That's different from what Advocate Mpofu said, and he
Yeah.
said he's not relying on it.
Sure. Let's clear that up.
Yeah.
Advocate Mpofu.
No, Chair, really. I never said that. I said I'm not going to rely on the truthfulness. The hearsay rule is about veracity. You know that. That's basic law of evidence. Okay. So if I say there was an article yesterday which says the chairperson beat somebody up in the committee, I can adduce that evidence for two purposes. If I'm adducing it to show that the chairperson indeed beat up somebody, then it's hearsay. But if I'm adducing it for the purposes of showing you that there is an article that says that, whether it's true or not is a different matter. Do you understand the difference? So the hearsay rule does not apply in the first instance. And that's what I meant when I said, of course, I'm not going to rely on the journalists might have their own spin and what have you. I'm not interested in that. All I want is to say that there were these articles which happened as the witnesses actually resolved this by saying those articles were published long before the sealing even happened. So assume there was no sealing that had happened, then this objection would not be coming. So all we want to do is to say these articles came out long before the High Court even got involved in this. And is this part of the information? In fact, we've already done that in the previous paragraph 263, which refers to Ms. Marion Spark and Policy Dukwana and what have you. That's the information that was before the public protector. And we're simply adding other information, which we were just for reference purposes using those articles. But it's not going to change. It doesn't change the fact that the articles are there. The absurdity of this situation, Chair, is that these are articles that are in the public domain, but they must be sealed, quote unquote, here in this committee. I mean, that's just ridiculous. If they are in the public domain, they are in the public domain right now as we speak. So why would we want to run away from them simply because in another context, they form part of sealed information?
That was not my understanding that assumption that it must be sealed here. I didn't get Advocate Bauer to say that, but the key issue is that, which is important for me as a chair of the committee, that in the work we're doing in trying to get to the bottom of issues and to the truth, and also based on what you said at the very beginning, we're not going to use this space to ventilate what would have been sealed. I don't even know what would have been sealed.
You can Google
So we don't utilize the space of this committee to get into, to encroach on those issues. It's very important.
I agree.
Before I go back to you, Advocate Bauer.
Chair, judging from where your ruling essentially on this is, perhaps what we need to do is maybe two things, is link it to which provisions in the, or paragraphs in the report this evidence leads to, and where Advocate Mpofu is then going with this.
All right. You know,
does that help?
Yeah, it does, Chair.
Okay.
In fact, let me do it like this to assist. Maybe
can switch in on again. My apology.
I need to correct something, Chairperson.
Okay,
The evidence leader is saying I said I never said I relied on those media articles. I was just saying the evidence which was before me, and then the report was published, and before the sealing of the evidence, that's what I'm trying to confirm and to prove a point that I am dealing with the untouchables and why I would want us to confirm that this is the evidence which was before me, because all those three bank accounts and how the money went through. And one of the people you'll be showing now, or who was the benefactor, is the sole director of Reatenda, which is in the report, but maybe Advocate Mpofu will show you. It's fine.
No, I think, Chair.
thank you, Advocate Mpofu.
Yes,
You start here and
Yes,
then you.
yes. No, in fact, I'll start with you, Chair, because I think you are proposing some compromise. I think, sometimes they say a pause resolve a problem, especially when it's non-existent. Yeah. So this is what I'm going to do, Chair, in line with what Advocate Bayo is suggesting. I'm going to go into the information that's in the report, and then after lunch, maybe after she has had lunch, or maybe me and her will discuss it. Yeah. Then go. In other words, let's assume there are three types of information, Chair. There's the information that we've read in that paragraph. And then there's information that's in the report. Oops. None of that is controversial.
Just pause. Just pause. Honorable
People are having
Jamaat.
lunch already.
No, Honorable Jamaat, please keep your place. I see there's a traffic with you. Thank you. Please keep your space. We're about to go to lunch soon.
Yeah.
Over to you, Advocate Mpofu.
Thank you, Chair. So I was saying we have three types of information. There's the paragraph that I read. There's the information in the report. Those are not. There's no controversy. The only controversy is around this, the third type. Yeah. So I'm going to pack this third type and we'll deal with it after lunch. So what I'm going to do now is to deal with the information that is not controversial, that is in the.
Okay, go ahead.
Yes.
Thank you. And I'm also trying to protect you from Honorable Jamaat.
Yes, please, Chair. Yeah, please. Yeah. That's why I'm sitting like this. No, it's okay. Right. Okay. Public Protector. Let's, because I just don't want to waste the time of the committee, and because later I'm going to be making requests from the chair, seeing that we're traveling today. So I want to be in his good books. Yeah. So this is what I'm going to do. I'm going to take you to some of the Advocate Bao says where in the report. So let's go to the report. Yeah. And then if there's anything outstanding, we'll then go to the. Can you go? Oh, sorry.
Yes.
Maybe to assist Advocate Mpofu, I don't have an issue to. I know what you're trying to break down the amounts stuff in the report. Maybe I'm preempting.
Yeah, we'll discuss it at lunch.
Yeah.
That's fine. Let's not involve the
Okay.
committee.
Proceed.
Thank you. Can we go to paragraph 82? I'm sorry, page 82, Tsepo, of the report. Paragraph 5.3.10.60 pp.
Okay.
Right. Okay. So let's use the root of the report here. So the heading there says, yeah, evidence on the disbursements of funds from EFG2 trust account to several beneficiaries, including Reatenda Trust, Linked Environmental Services, and the Cyril Ramaphosa Foundation.
Correct.
Right. Okay. So can we then go through those disbursements, which is the information that was in front of you? Okay. Let's not read the first paragraph because we're almost at lunchtime. So I'll paraphrase. That's the information that you subpoenaed from EFG2.
Yes, the bank records.
The bank records, right? Okay. And then the easy one that we've spoken about all morning is 5.3.1061. That's the 500,000. We've spoken about that.
Correct. That was transferred from Mr. Watson's personal account.
Mhm.
Actually, the 3 million was also confusing because it was 3 million into Mioto trading, and then eventually into the EFG2 trust account. It was only 500,000. So the other 2.5 million was for other payments,
Yes. All right.
not to the donations, but their operations as Busasa.
Right. Okay. Yes. Okay. I remember that. And then maybe let's start reading from 5.3.10.62. We might not be able to read all of this, but we'll continue after lunch. So can you read that out?
I can also confirm that large sums of money were transferred by various benefactors into EFG2 trust account for the CR17 campaign, from where it was dispersed by the attorneys to several beneficiaries, including Riatenda Trust, Linked Environmental Services, and Cyril Ramaphosa Foundation, to name a few.
Right. Okay. Now then we get to the
Maybe before we get to that, I think even in the report, we will find it, and just for Honorable Mailham's benefit, where we are specifically clear that we are investigating the president as the deputy president by then. Hence, I said I don't agree with the facts which were portrayed in court or in the court judgment. Thanks.
Yes. No, I think Honorable Amailam understands that now. I said somewhere in the morning, maybe he was not here yet, was that we are, when I say the president, I just mean the president today, like President Ramaphosa. But the report was about him as deputy president. So otherwise we'll all get confused. Now we have to remember to call him deputy president or to call him president. I think everyone understands that. Yeah.
Correct.
Thank you. Yeah. All right. In fact, even in the judgment, they call him the president, but it's on this understanding. Yeah. All right. Then the next thing is then, if you can go through those figures, big figures. I hope you don't have that problem of
read the first three.
Certain former president.
So from the evidence received by my office, an amount of 191,482,227.43 was deposited into this EFG2 ABSA trust account between 6 December 2016 and 1 January 2018. So it was almost a period of 2 years or 1 year, some months. And the 190,108,227 was transferred out of this account in the same period. So due to it was a very complicated financial analysis process. So, and having a lawyer investigating the matter, it was difficult for us to just, because we should have all the information. And I mean, these 190 million who were paid for that. So we just summarize key issues. Yeah.
Okay, fair enough. In other words, you did what to call bush accounting. No, I know. It looks like the people who have problems with figures are us lawyers and presidents. Yeah. because even the current president is struggling with the figures. Yeah.
Yeah.
All right. So, okay, but in any event, let's not get into all that whole list. Let's use that one so that we can then break for lunch. Let's just use that one as a let's call it as a model of the point you're making, which is that you said there was an amount which came in. Let's call it that for those of us who are not accountants. There's an amount which came in of about 191 million, and it's dispersed, and those disbursements are almost around the same figure, another 190 million, give or take a few rands and cents.
Correct.
So you're able, yeah, I remember this is the worst thing when you actually study accounting. It's when the figures don't actually balance. But roughly, you could see that this is the money that came in and there's the money that came out.
Okay. Yes.
All right, good. Okay. I
And
don't
then
think
the next paragraph.
yeah. The next paragraph then is, so the first, that's the amount of 190 million. The next one?
Then the next one, evidence from bank records again reflect that an amount of 388 million 544 340 34 was deposited into Standard Bank South Africa of Reatenda Trust account between 1 January 2017 and 20 February 2019. So it's a period of 2 years almost. And then from that, almost 388,518,464.55 was transferred out of it in the same period.
Yes. Can I ask, with the permission of the chair, you don't have to read those rands and cents at the end. We all understand that you are lawyers, the figures didn't balance to the last cent. So you can say 388 million, and then we just move. Yeah.
Okay.
Yeah, he's
So
interested in the millions. So.
Yes.
Yes, so that's what we discovered.
Mhm.
And then the next one is records also reflect that there was a 441 million
Mhm.
which was deposited into the FNB account of Linked Environmental Services between 15 December 2016 and 13 February 2019. And during the same period, an amount of 441,147, was transferred out of this account during the same period.
Okay, so next one.
And then there was an amount of 335 million was transferred. In fact, is it million? Eh? Transferred from Linked Environmental Services FNB account.
Yeah.
It's 335,000 or million.
Sorry, that's that's which province are you from? There's a problem. Oh, Mpumalanga, they can do these things. Yeah. All right, I think it's only Advocate Shabalala. All right. No, I think that one, the point, we're going to assume that the comma is after the 738. Yeah.
Yes.
So,
okay, so
let's say 335,000. Yeah. So I think the chair is right. Yeah. Okay.
From
Next
this
one.
linked services into Cyril Ramaphosa Foundation between 20 July
Mhm.
2017 and 26 March 2018.
Right. And then the last one.
The last one was, out of all the donations received for the campaign, records reflect that there were 3 single largest donations of 30 million on the 9th of March 2017, 39,620,000 on the 29th of September 2017, and 51 million on the same date into EFG2 ABSA Trust account. And that came from the same donor.
All right. Then the punchline from which we will take this when we come back from lunch is at 5.3.10.67. If you can read that into the record.
In conclusion, on the above revelations relating to exchanges of large sums of money, some of which received from private companies, I wish to express my preliminary view that such a scenario, when looked at carefully, creates a situation of the risk of some sort of state capture by those donating these monies to the campaign.
Right. So that's your finding.
Yes.
Having done all the analysis and the accounting and the moving the money from this one to the other. And sorry, Chief, just for the sake of completion, that language of something that could create a situation of the risk of some sort of state capture or conflict or some wrongdoing or whatever, mirrors the prohibition that is placed on members of the cabinet in section 96 of the Constitution. And we can start from there after lunch.
That's correct, because
Yeah.
when we go to the legal framework and the applicability of EMIA and section 96, that's what we were basing our findings on.
Thank you. And well, okay, I'm stretching my luck. You can confirm that I think in the Nkandla judgment, Chief Justice Mkhwebane had said that what is prohibited is not so much that the risk must materialize, but the risk of such a conflict is sufficient to breach section 96 on the part, in that case, of the former President Zuma, correct?
That's correct. Actually, it's how even the Executive Members Ethics Act is crafted. You just need you shouldn't expose yourself
To the risk.
even if it doesn't materialize that risk, but you should just stay away.
Okay, thank you, Chair.
Okay.
We'll start from there.
Thank you. We'll take lunch for the next 45 minutes back at 2. Thank you.